good day guys. Today we will just continue our discussion on the subject criminal justice system, specifically the first pillar, which is the law enforcement pillar. So to start, I have this figure, the pillars of criminal justice system, which again the law enforcement, prosecution, the court, correction, and the community. If a person committed a crime, he will undergo in the process of the pillars of criminal justice system. And the first pillar he will be undergoing is the law enforcement pillar, which I mentioned earlier will be our subject matter for today's discussion. So law enforcement pillar is considered as the prime mover or initiator of criminal justice system. It is said to be the prime mover because it is the one who initiates the justice process by arresting the violator. As you see in the illustration, this pillar is installed at the forefront of criminal justice system, meaning they are the first contact of the offender. Aside from initiating the criminal justice system through conducting arrest of such offender, this pillar is also the agency of the community or government that is responsible for enforcing the law, maintaining public order, and preventing and detecting crimes. And take note, guys, that it is not accurate to consider law enforcement agencies to be exactly the same with police. This is because there are other agencies of the government which are charged with enforcing laws aside from Philippine National Police or PNP. As for instance, the Philippine Drug Enforcement Agency, or commonly known as PDEA, which is considered as the lead anti-drug law enforcement agency responsible in enforcing the penal and regulatory provisions of Republic Act 9165, otherwise known as the Comprehensive Dangerous Drugs Act of 2002. Hence, PDEA may also be considered as a law enforcement agency. So next, we have the different police activities. To simplify and in memorizing the different police activities, just do not forget the acronym PRASIP. So P stands for prevention, R stands for repression, A for apprehension, S stands for search, I for investigation, and P stands for protection. But it must be stressed further that these are only the simplified police activities, wherein the complete list of the powers and function of Philippine National Police is provided under Section 24 of Republic Act 6975 or the DILG Act of 1990. So let us discuss police activities one by one. So first, they prevent crime. Prevention of crime is intended to prevent root causes of crime. Example of root cause of crime is the evil intent of a person to commit crime. Second is repression or suppression of crime. This police activity is done to reduce the opportunity of a person in committing a crime. So, and you may ask, what is the distinction between prevention of crime and repression or suppression of crime? The distinction between the two may be understood by explaining first the formula of crime. So this is the formula of crime, which can be interpreted as follows. If the combination of the desire and opportunity is stronger than the resistance, crime will be committed. If the combination of desire and opportunity is weaker than the resistance, crime will not be committed. So what is the distinction? In prevention of crime, the law enforcement is strengthening the resistance and weakening the desire of a person in committing a crime. In repression or suppression of crime, on the other hand, the law enforcement is reducing the opportunity of a person in committing a crime. Example of this is the act of conducting patrol by police officer. The next police activities are they also conduct search and seizure. They investigate crime, protection of lives and property, and apprehension of offenders. Apprehending offenders is also known as arresting of offenders. And under Section 1, Rule 113 of Rules of Court, arrest is defined as taking of a person into custody in order that he may be bound to answer for the commission of an offense. And an arrest is made by an actual restraint of a person to be arrested or by his submission to the custody of the person making the arrest. We have two modes of conducting arrest. First, arrest by virtue of warrant of arrest, and second one is warrantless arrest or the so-called citizen's arrest. So let's define first what is warrant of arrest. The warrant of arrest is an order in writing issued in the name of the people of the Philippines, signed by the judge, and directed to a peace officer, commanding him to arrest a person or persons stated therein and deliver them before the court. For a warrant of arrest to be valid, first, it shall be issued upon probable cause. And second, such probable cause is determined personally by the judge upon examination under oath or affirmation of the complainant and the witnesses he may produce. And take note, guys, oath is applicable if the person swearing believes in God, and while affirmation is applicable if such person does not believe in God. And the last requisite is that warrant of arrest must particularly describe the person to be arrested. In other words, what is the so-called Doe Warrant? So a Doe Warrant is that issued for the apprehension of a person whose true name is unknown, and only the characteristic of such person is described in the said warrant. If you may ask if it is valid, even if the name of the person to be arrested is unknown, yes, it is valid, as long as it satisfies the constitutional right of particularity, provided the person to be arrested is sufficiently described, which will enable the arresting officers to identify him. How about the lifespan of warrant of arrest? Until when that it will be valid? Under Section 4, Rule 113 of the Rules of Court, as long as the person is stated in the warrant of arrest is not arrested, it shall remain valid even if several years already lapsed. However, the head of the office to whom the warrant of arrest was delivered for execution shall cause the warrant to be executed within 10 days from its receipt. Within 10 days after the expiration of the period, the officer to whom it was assigned for execution shall make a report to the judge who issued the said warrant. In case of his failure to execute the warrant, he shall state the reason for its non-execution, but take note, the validity of the warrant is not affected. And take note further, under Section 3, Section 4, and Section 6 of the Rules of Court, an arrest may be made on any day and at any time of the day or night. And the second mode of conducting arrest is the warrantless arrest or the so-called citizen's arrest. And the three instances of warrantless arrest are as follows. First, under paragraph 1 of Section 5, Rule 113 of the Rules of Court, an arrest may be conducted when in the presence of the arresting person, the person to be arrested has committed, actually committing, or is attempting to commit an offense. This instance can be described as in flagrante delicto. In flagrante delicto is a Latin term which means caught in the act of committing a crime. Second instance is that when an offense has just been committed and the arresting officer has probable cause to believe, based on personal knowledge of facts or circumstances, that the person to be arrested has committed it. And last instance, when you can arrest a person without warrant, is when the person to be arrested is a prisoner who has escaped from a penal establishment or place where he is serving final judgment or is temporarily confined while his case is pending, or has escaped while being transferred from one confinement to another, and the person is known as fugitive of justice or escapee. It must be stressed further that the enumerated instances are also known as citizens' arrest, which are instances that private persons may conduct arrest because private persons cannot serve a warrant of arrest, because to arrest a person by virtue of a warrant is an exclusive authority of police officer. Next is, what are the rights or authority for police officers conducting the arrest? First, under Section 10, Rule 113 of the Rules of Court, an officer making a lawful arrest may orally summon as many persons as he deems necessary to assist him in effecting the arrest. Second, under Section 11, Rule 113 of the Rules of Court, an officer, in order to make an arrest, either by virtue of a warrant or without a warrant, may break into any building or enclosure where the person to be arrested is or is reasonably believed to be, if he is refused admittance thereto after announcing his authority and purpose. Third is that the police officer have the right to break out from building or enclosure. Whenever an officer has entered a building or enclosure to conduct arrest, he may break out therefrom when necessary to liberate himself. And last, what if the person lawfully arrested escapes? Under Section 13, Rule 113 of the Rules of Court, if a person lawfully arrested escapes, any person may immediately pursue or retake him without a warrant at any time and in any place within the Philippines. And take note, this is known as hot pursuit. And take note further that the phrase hot pursuit may also be called as fresh pursuit. And so that's it for today. Thank you and God bless.